Hello everybody and welcome back to our studies in the history of English law. This lesson is going to talk about the first of the two sort of pre-Norman conquest areas that I want to explore when thinking about the history of English law. The first of these is, of course, looking at the influence of Roman Britain and the Roman law and what the Romans brought essentially to the English legal system. And then the second of those will concern itself with the development of law under the Anglo-Saxons and through the Anglo-Saxon period. So this lesson is going to be the first of, I think, 3 or 4 lessons looking at the history of the English legal system, beginning with Roman law and looking at the Roman influence on the English legal system. I believe it's about 3 or 4 lessons. About 2 or 3 lessons looking at the influence of Roman Britain. And essentially what we're going to do is look a little bit at the historical foundations of the English legal system prior to the Norman conquest, beginning with this idea of the Roman law. And remember, this first half of lessons is going to be we're going to be concerning ourselves almost exclusively with the development of the common law, because the development of the common law sort of takes some foundations in the Roman period and then more importantly in the Anglo-Saxon period. And then as time goes on through the Norman conquests, and then eventually when we get to the sort of Angevin Empire, we get to see the development of the common law more succinctly. And then as time goes on, we will start to think about the influence and the role of Parliament as Parliament starts to develop and take on a greater and greater role within the English legal system. This lesson is going to explore the historical context of Roman Britain. We'll talk about the specific legal traditions that the Roman law influences over the next couple of lessons. We'll talk a little bit about the Roman law in this video as well. But I want to begin by just talking about Roman Britain. Okay, Roman Britain from around 43 AD to 410 AD was really where we start to see the first influences on the common law. Okay, the Roman influence on the development of the common law is subject to quite a lot of interesting interest and insight, specifically when we're thinking about the extensive legal legacy that the Roman Empire left. You have to think the majority of the civil law across most of Europe dates its origins to the Roman Empire and to the Roman legal system. And just like how the Romans exported things like Christianity across most of Europe, they so too also exported a lot of legal traditions across many parts of Europe. And now, the reason why we're going to be spending more of our time focusing on Anglo-Saxon influences over the development of the common law and not as much time looking at the Roman law specifically is because the Roman law didn't directly form the basis of the English common law, unlike the direct principles that we see in the majority of the civil law traditions in Europe. The Roman law didn't sort of take hold and capture the kind of foundations that it did across Europe. Okay, that doesn't mean there was no influence whatsoever. There are still little bits of influence that we can see when looking at the Roman law and the influence of Roman law on the English legal system. But for the most part, we can't see necessarily a clear connection from the common law, from the Roman law to the common law, if that makes sense. There are like little bits of influence, but it didn't take hold in the same kind of way that the Roman law did across in Europe. So let's just think about the Roman legal system in Britain. Roman law generally was formalized and a codified system, okay? This is a really important point. We will study Roman law in the future as its own separate series of lessons. But one of the things that we see was that the Roman law was primarily used to govern Roman citizens and soldiers that were stationed in Britain. Okay, so in the same way that they would control Roman citizens across other parts of Europe, they also would control parts of Britain. The provinces of the empire, including Britain, operated under a dual system of legal tradition. You have firstly the Roman civil law, okay, and the Roman civil law would apply to Roman citizens. It included things like property laws, personal rights, contracts as well. You also then have the provincial Roman law. The provincial Roman law would apply to the native population. So the system of law that was applicable when the Romans had control of Britain was a system of law which was divided among the civil tradition, the civil law itself, which applied to Roman citizens that were stationed in Britain, and then the provincial law, which would apply to native populations. This was a little bit less codified, a little bit less formalized, and that's one of the reasons why, when the Romans eventually leave Britain and we start to see the Anglo-Saxons, the Angles and the Saxons start to colonize and start to take hold of the British Isles, we see that the Roman law itself that did not survive in the same kind of way that it did in places like across Europe and whatnot. So essentially, the presence of Roman law in Britain did bring about more organized governance, and of course brought about legal systems in certain areas in the same kind of way that it did across a lot of the Roman Empire. Towns had Roman-style courts. They handled legal disputes. They had Roman magistrates that administered justice according to the basic principles of Roman law. But for the most part, and for the majority of the native population, particularly when it comes to rural areas, which was the vast majority of Britain at the time, there was just the following of local customary laws. So the Roman law didn't really have the kind of in-depth influence over the majority of the population, the majority of the native population. During the Roman occupation, several important legal concepts were still nevertheless introduced. So the Roman law was codified. It was written down, unlike the sort of customary laws and traditions that existed within the rural areas of English society. A significant shift we see, obviously, from the sort of oral customary law of the native Britons. The Roman system of courts and legal officials, such as judges and magistrates, would eventually come to influence the development of a more formalized legal institution in Britain. So that's one of the things that we can sort of take from the Roman legal system as being influential from all the way back in the history of English law. Roman property law also was quite influential, including things like the idea of dominium, brought about more structured land tenure systems. And the Roman practice of issuing land titles and legalized transactions also helped influence land laws even after the Romans withdrew. So, as I mentioned at the start of this lesson, the common law wasn't a direct descendant from a Roman legal system that sort of stayed and has quite a lot of significant influences, but you can still nevertheless see some significant influences that remains even to this day within the sort of English legal system that comes from the Roman tradition and from the Roman legal concepts. And that makes sense given the sort of 400 years of occupation that we see within Roman Britain. But it is really when the Romans leave and we see the Angles and the Saxons take over that we start to see a true codification of the English legal systems. But even in that sense, the inflection point of the Norman conquests leads to another set of developments of legal principles and legal systems with things like feudalism and the development of such a system in that regard. So essentially, what we can conclude is that the English legal system is something of an amalgamation of all of these different prior systems that existed, taking little bits from each one and developing it and making alternative points, making alternative reforms and making alternative little changes here and there. And this has certain influence in terms of why we should study the English legal system and why we should study the Roman law and the influence of Anglo-Saxon law. But it is quite unique compared to that of, for example, the United States, that has a significant point at which a legal system develops, which is, of course, with the American Revolution and the establishment of the Constitution. And the similar thing we can see when we look at the revolutions in Europe. And this is one of the reasons, in fact, why we don't have a constitution, whereas places like France and Germany and the United States do have a sort of codified constitution compared to ours, because our history is very different. And that's one of the things that I want to sort of just keep on drilling into people when we are thinking about this study of history and this study of legal history in future lessons' time.